Yeah, I was going to say, now, even if we accept the very wrong interpretation of Article 94 2A, the court, the High Court and the Supreme Court have so completely made so many errors in this case that it is baffling. Let's go to the Cape Coast Court.
Yes, because you make 4 specific allegations against the judge.
Yes.
Against the judgment, rather, not the judge, against the judgment.
Yeah, the first one is that the judge was engaging in streetlight jurisprudence.
What does that mean?
Streetlight effect, or the drunkard search problem, is an observational bias, Randy, where people, someone, a drunkard who had lost his money, was looking for his money in a place, and the police finds him and says, "Why are you looking for your money here when you misplace your money 2 blocks away?" And the drunkard basically says, "Well, I'm looking for my money here because there are more lights here." Article 94 2A talks about owing allegiance to a country other than Ghana. It says nothing about citizenship or renouncing citizenship. Hello?
Yes.
Are you there?
Yeah, I'm here.
Okay. It says nothing about renouncing citizenship, merely because it is much easier to look for somebody's certificate of renunciation doesn't mean it means allegiance to a country other than Ghana. That doesn't make sense. What you have to look for is whether or not the person has disavowed allegiance to a country other than Ghana. And so you have to look at Canada law, and then when you look at Canada law, you have to say, in Canada, what does it mean to disavow allegiance? What does it mean to owe allegiance? If you did that, you read the Canadian cases on allegiance. And the classic one is McCarthy versus Canada, a 2014 case where a Canadian court said, look, this whole business about swearing allegiance on becoming a citizen is a mere symbolic commitment to be governed by Canadian law. And the applicants were saying they don't want to swear that because they don't believe in what the allegiance was asking them to say. The oath was asking them to say. The guy said, look, this is just a symbolic commitment. Just swear it, become a citizen, and the following day, you can just disavow it. Disavowing it has no effect on your citizenship status. So there's actually a website where people, it's called disavow.canada, where people just get up and disavow this allegiance. That is how you should apply the test, not your thinking that citizenship is allegiance and therefore I have to look for your renunciation. So the streetlight jurisprudence is this idea that the judge ignored what the Constitution was saying. The Constitution said, oh, allegiance. The judge says, well, that's too complicated to figure out, so I'm going to replace it with renounced citizenship. Not just renounced citizenship, but renounced citizenship as at a particular date, which is also wrong anyway. The second problem, Randy, is on a matter like owing allegiance, there are factual disputes. The MP is saying he can prove that he does not owe allegiance to Canada. The plaintiff is saying he can prove that the MP owes allegiance to a country other than Ghana. So there must be a trial for the parties to prove what they are alleging. The MP, for instance, could have brought in experts from Canada to explain what allegiance means and to show that he has disavowed that allegiance. He could have basically showed that he never owed allegiance, or he never intended to owe allegiance, or he could also have shown that he reasonably and honestly believed that he no longer owed allegiance after he had turned in his certificate of renunciation, his passport, and he had moved to Ghana. When he moved to Ghana, he could no longer go to Canada because he no longer was a citizen. He had turned in his passport. he attained in his certificate of renunciation. He could have proved all that. But the trial judge preempted all that by issuing what we call a summary judgment. A summary judgment means the judge decided the question as a matter of law. He did not allow a trial, which means the MP was not given a fair trial on two separate grounds. Ground number one, the plaintiff was discharged of its burden of proving that he had the facts to support his claims. And then number two, the MP was denied the right to show that whatever factual allegations were being made against him were false. So there was no fair trial. There was no fair trial. Funny enough, the Supreme Court in its injunction says that the High Court judge gave a judgment after a trial. Well, that's a huge mistake because there was no trial. There was a summary judgment. And if the Supreme Court is saying that the High Court judge gave a judgment after a trial, it suggests that the Supreme Court itself did not understand what happened in Cape Coast. That by itself is enough for any country or any group of judges who are serious about their judicial oath to immediately come back and arrest the injunction and to arrest the High Court judgment because it denied the MP this fair trial. The third problem is that the Constitution says very expressly that whenever at trial in a lower court or whenever there's litigation in the lower court and a question arises as to what an article of the Constitution means, the judge should stay proceedings and refer the matter to the Supreme Court. That is mandatory. The judge shall. So the only question to ask is, did an issue of interpretation arise in the lower court, in the Cape Coast Court? The answer is yes. Why? Because there's a case that tells us how you should determine whether or not an interpretation issue has arisen. It's called ex parte accusa. And ex parte accusa has 4 wings. 2 of the wings were met in this case because, number one, Article 94(2) is inherently imprecise, vague, and ambiguous. And number 2, because the parties in the case put rival meaning on Article 94(2)(a). For one, it meant citizenship. For another, it meant allegiance. And the judge should have stopped and referred it to the Supreme Court. Now we know that he should have, because the plaintiff who has won the judgment at the High Court himself has gone to the Supreme Court and he said, look, Mr. Supreme Court, the High Court judge did a bad thing. He should have referred the case to you. He didn't. So I'm coming here to, on my own, seek an interpretation. That idea that the plaintiff who prevailed at the High Court has come to the court to seek interpretation, one of the judges should have said, but if you are here seeking an interpretation, then the judge's statement that the Article 94(2)(a) is clear, precise, and unambiguous, and therefore should not be referred to us, is wrong as a matter of law. And if it's wrong as a matter of law, then we cannot enforce any injunction, assuming the Supreme Court was minded to enforce the order of the High Court anyway, which itself is bizarre that a Supreme Court enforces the injunction of the High Court. So that is
Prof, I find something quite intriguing. At the High Court, the plaintiff's case at the Supreme Court that you referred to was actually the prayer of the defendant at the High Court. And the plaintiff's view was the reverse, that they didn't think that it was a matter that should go to the Supreme Court. However, the same plaintiff that did not think that the defendant's view at the High Court was proper is now at the Supreme Court asking for what they thought that the defendant did not deserve at the High Court. That's strange.
Absolutely. Absolutely. And that's what, in the article that you referred to, I say the plaintiff was doing the Rashikoko dance.
Welcome back.
Thanks, Randy. Sorry about that.
No, that's fine. That's fine. Technology. So you are dealt with the first three issues. It left with the fourth one where you say the judge cancelled the elections contrary to PNDC law 284/20D.
Yeah, PNDC law 284/20D is very clear on cancellation of elections. It says if you want to cancel elections because of a disqualification, the test has to be applied at the time of the person's election. That is December 7, 2020. So on December 7, 2020, was the person qualified? If the answer is yes, don't cancel the election. So even if the MP is not qualified, but somehow managed to be qualified at the time of the election, then the Constitution provides ample deference for the wishes of voters and wants to protect what the voters have said. So if you apply 284/20D, you would see that, yes, the election should not have been cancelled because the NP, even if you want to accept the flawed theory that renunciation of citizenship is the proper test, then the MP is still qualified because he got his renunciation somewhere in November and the election manager cleared him and he was therefore eligible to run under 284/20D.
All right. Okay. Now, well, yes, Prof.
There are so many other problems. For instance, in not referring the matter to the Supreme Court, the High Court relied on ex parte Zanitor. It's saying that Zanitor controls Article 94(2)(a). Zanitor, on the other hand, has nothing to do with allegiance to a country other than Ghana. Zanitor deals with whether or not one is a registered voter and when the Electoral Commission should inspect whether or not you are a registered voter. In that case, the court said that the proper time for inspecting whether or not somebody is a registered voter is at the time of filing his nomination or her nomination. But that's it. But there's nothing interesting about that judgment, because if you look at PNDC law 284, 9A and 91A and 92A, there's that distinction already built in, because PNDC law 284, 91A says a person should be qualified as a candidate at the time he files his or her nomination. So if to file your nomination papers, you have to be a registered voter, not just because of ex parte Zanitor, but because of PNDC law 284/91A. But if you go to 92A, there's a change in the language. Now, it says very specifically, a person who owes allegiance to a country other than Ghana shall not be qualified to be an MP. That basically means when it comes to owing allegiance to a country other than Ghana, it has nothing to do with filing your papers. In fact, it applies only when you are in parliament. Even now, somebody who is in parliament, if after following due process, it is established that the person owes allegiance to a country other than Ghana, he should be kicked out of parliament. That thing is not something that you determine on one day. No, it is continuing because it relates to an action that can be taken, and whenever that action is proven to have been taken, then the disability kicks in, or the disqualification kicks in. So it was very wrong for this court to confuse Article 94(1)(a) to Article 94(2)(a), or to say that ex parte Zanitor controls Article 94(2)(a). Ex parte Zanitor has nothing to do with Article 94(2)(a). Registered voter is not an ambiguous term. Allegiance is a very ambiguous term. All
right, Prof. Let's see how the Supreme Court handles this issue. And of course, there are also a plethora of cases filed by the Honorable Question's legal team. So we'll see how it checks out. But I'm sure you've heard about an allowance called neutrality.